having understood the parliamentary functions, the legislature and the lawmaking aspects of both the central and the state government, it is important to understand certain legislative interpretations which is used in the process of lawmaking. To understand that, we now understand three different types of lawmaking. One is the legislative lawmaking, second is the executive lawmaking, and third is the judicial lawmaking. But most important of all is the legislative lawmaking through the parliament and the state legislatures. The executive lawmaking is through the delegated legislation whereby the parliament has already framed law in a broader perspective and has left certain areas for the executive to make certain laws, rules and regulations for its functioning, and this is called the executive lawmaking. The judicial lawmaking is a trend through a judicial activism where the higher courts of the land have made certain decisions and that has become the law. That is called the judicial lawmaking. If we understand the word sovereign in the preamble of the Constitution, it means that it is the power of the parliament to make law. Sovereignty in the political science term has territorial sovereignty, which says that within the territory of and the boundaries of its nation, the country has an absolute power of lawmaking, that is the territorial sovereignty, and therefore India has a territorial sovereignty of what constitutes the Union of India to make lawmaking in its sphere of the nation. So the word sovereign is a very important source of power for legislation and lawmaking for any country, and therefore the preamble states India is a sovereign country. Legislation consists of the declaration of legal rules by a competent authority. And who is a competent authority? An elected government is the competent authority. The parliament is a competent authority which has the sovereignty to make law regarding to its subjects. So therefore, sovereignty is an essential aspect to make legal rules which is to be followed. Now in India, the sovereign and competent authority is the parliament. Article 245(1) of the chapter 11 of the Indian Constitution states, subject to the provisions of the Constitution, Parliament may make law for the whole or any part of the territory, and the legislature of the state may make law for the whole or any part of the state. This is the constituent power and the source of power for the legislature for its lawmaking. Now, if we look into the Salmond, who was a pioneer in political science, he says that legislation is a source of law which consists of the declaration of legal rules by a competent authority. Competent authority in a bicameral legislature can also be a state government. In a federal structure, it can also be a state government or a central government. Now, legislation is an important source of law. Like any other source of law, but legislation forms the primary and main source of law as it derives power from the people for its lawmaking. Article 245 to 254 of the Indian Constitution talks about the legislative powers. Dr. B.R. Ambedkar, who was the president of the drafting committee, stated that the states are autonomous and they are not entirely dependent on the center for legislative or executive authority. They are on equal footing with the center. Article 246 of the Constitution grants the Union and states their authority in the spheres of their legislative, executive and financial functions. There is separation of power in the strict sense of legislative, executive and judiciary, but in India, as I've already discussed, there is not a strict separation between legislature and executive, but there is a division of power between the states and the center in the matter of legislatures. The central government has its own sphere of lawmaking. The state government has its own sphere of lawmaking. The Indian federal system, as like many other countries, was not founded by the treaty or an agreement among the princely states. After the independence, all the princely states agreed and accepted to the sovereignty of the nation, and therefore their accession to the union was absolute. And this is precisely the reason why Indian system of federalism is more unitary in character. for the sake of unity and integrity, and already discussed the no states or the formerly princely states which became the states later does not have any power to secede from the union government. The division of powers are under state list, central list and the concurrent list under the 7th schedule. This reflects the unitary characteristics of the constitution. The unitary list has more subjects for legislations than the state list. The concurrent list is a list where both the state government and central government have the power to make law, but the parliament takes predominance over the state legislations for the sake of unity, integrity and uniformity in certain legislations which is required. The parliament can enact legislations on the subject matter of state list in case of state emergencies or the governor rules in the circumstances prescribed by the constitution. And therefore, after reading the provisions under 7th schedule, Indian constitution is unambiguously in the favor of centralization within the federal framework. Now, Article 246 Clause 1 states that Indian constitution, the parliament can make law enumerated in list 1 of the 7th schedule. This list contains matters such as foreign affairs, defense, war, railways, as such, etc. Article 246 Clause 2 states that the state can also make law on the matters enumerated in list 3 in the 7th schedule. Now, this list 3 in the 7th schedule, the state can make law. Concurrent list is a list where both the state and the central government can make the law. Article 246 Clause 3 says that only the state has the power to make law with reference to the list enumerated in list 2 of the 7th schedule. This contains matters such as agriculture, fisheries, water, public health, sanitation, police, etc. Significantly, the residuary powers is with the central government. Any matter which is not listed in any 3 of the list, either state list, union list or concurrent list, is called the residuary power, and that is under the central government. This forms one of the basic centralizing tendency of the federal structure of India. The Supreme Court in a very famous case held that if the said statute is not relatable to any of the subject matter in the state list, then it is a matter of legislation for the central government. Either it has to be the union list, concurrent list or the residuary powers. Now, when we are having 3 different lists, there is always a question as to the interpretation as to what are the lists that falls under, categorically falls under the different lists, and sometimes there may be matters which requires more interpretation. In this very famous case, Union of India versus Dhillon, the Supreme Court held that the test for a central government, whether it has the powers to legislate, is to see in the list 2 of the state list if any of the provisions or related provisions is the subject matter of the state list, then only the state can make the law. If not, then the legislations can be made are found in the subject matters of union list, concurrent list, or it shall be under the residuary powers under Article 248. Another important features of centralizing tendency for a lawmaking and legislative interpretation is that it is a rigid constitution. Indian constitution is a very elaborate constitution in terms of lawmaking and in terms of amendment. The states does not have the power to amend the constitution. It can be done only by the parliament. And as you already know, among the 3 lists, the central government takes predominant of subject matters in the 3 lists. The judiciary is independent. The Supreme Court is the highest court of appeal in the country, but the states have high court, but there is only a single unitary Supreme Court in the center. So the central government has the power in the matter of international relations and diplomacy. The state's government does not have such powers. Now, the boundaries of the state is determined by the central government. The state's reorganization is done by an act of parliament, though it revolves around the state's subjects. And we already know that only few have the bicameral legislature, and therefore the representation to the parliament is more in a centralized nature. Regarding the matter of election, the Election Commission is the central authority, and all the legislations relating to the elections is done by the central government and not the state government. Though the provisions are provided in the constitution for the state government to make law relating to the election, predominantly the elections for the sake of uniformity, the law or regulations relating to the election is made either by the parliament or by the delimitation commission or by the election commission. Now, emergency is another important provision in the constitution which has the most distinguished feature of a unitary structure. Now, why it is important to understand whether the Indian federalism has a unitary structure with a federal feature, because the division of power under the three lists gains a prominence in the legislative sphere. Now, the deployment of armed forces into the state territories is prerogative of the central government. The taxation aspects like GST makes the central government have the financial supremacy. The union government has sweeping powers in the economic terms and also in terms of allocation of resources to the different states of the country. Now, this actually significantly signifies the structure of the Indian federal structure of division of powers. The state government is actually a little on the lower side for legislative spheres of lawmaking. The central government has an upper hand in the lawmaking. This is called a strong unitary features in the federal structure. Now, Article 249 in the Indian Constitution says that if there is a matter in the state list which has become the matter of national importance, then the center can make law. Article 250 also speaks about how the union can make law on the matters included in the state list in times of national emergency. The best example and the recent example is the goods and service tax, the usage of Article 249. The GST was actually meant to amalgamate a large number of central and state taxes into one single window common tax to prevent cascading or double taxation. Now, this was also a matter of shifting of the economy from an informal to the formal one. This taxation of GST did not exist before. The taxes relating to goods were under the state list of entry 52 of the 7th schedule, which was on the tax on the entry of goods into the local area of consumption, or the 54th entry in the schedule, which was about the tax of sale of goods or purchases. So, it essentially meant that these taxes were under the state list and not under the central list. So, the state had the powers to make law regarding the taxation. Therefore, the government had to amend the constitution in order to avoid the ambiguity and get the importance of tax under their control. Now, with the Constitution 101st Amendment of 2016, the government amended few articles in the Constitution in order to execute the imposition of tax. Article 246A was inserted under this amendment. So, it read, Article 246A Clause 2 read, Parliament has the exclusive power to make law with respect to certain goods, services tax, where supply of goods or services or both takes place in the course of interstate trade and commerce. The word supply gained significance because it was inserted instead of the word sale or purchase of goods. Because by the usage of the word supply, it was made into an exclusive list of the union government. Because as stated above, the 54th entry in the state schedule, the list was regarded with the state purchase or sale. Now, a similar thing can be seen in the amendment of Article 286, where the words sale or purchase of goods were replaced by the words supply of goods and services. This was done to get the services along with the goods under the ambit of the union government. Article 249 was also amended to add the words goods and service tax provided under Article 246 Clause A. This gave the centre the more power to enact any law applicable to the states mentioned in the state list, including the goods and services tax. Article 279 Clause A was also added to the Indian Constitution, which described the formulation of GST Council. The council would be a joint forum for centre and states. So GST Council is an important constitutional authority formed making an amendment to the Constitution and inserting the article of 279 Clause A. The final article with reference to the goods and services tax is Article 269A added through this amendment. So this was also pertaining to the goods and services tax. So all these are the powers of the union government where though there is a legislative spheres for the state, the union government can always take over certain subjects for its legislative lawmaking, and thus this characteristic is called the strong unitary structure with federal characteristics. Now moving on to another doctrine called the Doctrine of Pith and Substance. Now this is a doctrine for a legislative interpretation. This enactment substantially falls within the powers conferred by the Constitution on the legislature. Now it says that it cannot be held invalid merely because it incidentally encroaches on the matter assigned to another legislature. Now the state government makes law regarding to the subject matter in the state law. Sometimes when it encroaches upon the matters assigned to in the central subject, it cannot be held invalid. Now therefore the doctrine of pith and substance comes into picture. In order to examine the true character of the enactment, the entire act is required to be understood. Now when there is any dispute between the union and state, for example, on the subject matter between the union list and the state list. Now when you are making a law either by the state or by the centre, there is always a situation where certain provisions encroach upon the territory of either of the state list or the union list. At that time, the doctrine of pith and substance is interpreted by the Supreme Court so that which is more predominant than the other, so where the union or the state government can make the law. If the centre strikes down such a law, saying that the state governments have encroached upon its legislative ambit, it will be very difficult for the states to make any law, and therefore the courts have evolved a situation or a procedure or circumstances where the doctrine of pith and substance is applied to see which is the most predominant subject matter so as to ascertain the list, whether it is state list or central list or the concurrent list. Now it also has made states more independent in its lawmaking sphere. One such important case is the Tamil Nadu exhibition case, where the Madras High Court held the act as a whole was invalid, stating that the subject matter belonged to the central government and not the state government, and therefore the Tamil Nadu state government did not have the jurisdiction or the validity to make such law. Now the theatres and dramatic performances were subject to the provisions of entry 60 of the list 1 and held that section 9 clause 2 of the act was invalid as it specifically dealt with the copyright, which is a matter included in entry 49 under the union list. The court said that it agreed with the doctrine of pith and substance. It could encroach upon federal government, but it did not support the Tamil Nadu Act, stating that the pith and substance of the act essentially fell under the union list and not the state list. The Supreme Court, when the case went to the Supreme Court, however, it just said that the decision of the Madras High Court was reversed, stating that the act was valid because the pith and substance was not the copyright, and it was held the cinema was the pith and substance, the cinematic performances were the pith and substance, and therefore it was the subject matter under the state list, using the doctrine of pith and substance. the state list was ascertained as to what was the subject matter. Therefore, in this case, the Supreme Court held that essentially this was the subject matter of the state list, and therefore Tamil Nadu case was valid in its jurisdiction. Here, the main purpose of the act was to curb the infringement of the copyright. There were two subject matters. Essentially, it was up to the court to talk which subject matter falls under which category. Therefore, the court interpreted it to be cinemas and not copyright, and therefore it was under the state list and not under the central list. Another important feature is the doctrine of colorable legislation. Now, what is doctrine of colorable legislation? It is only when a legislature has no power to legislate, frames a legislation so that it appears to be within the competence is known as doctrine of colorable legislation. It states that it is a question of competency of the concerned legislature to enact the impugned legislation. The legislations cannot be transgressed, it can't be covert, can't be indirect or disguised. Such a legislature is colorable. Essentially, it means that it does not make law on matters, it doesn't have the power to make law on such matters, but is making law in a colorable format, disguising in law in such a way that it has to achieve the intended purpose without having actually the jurisdiction to do it. Simply says that legislature can't make any law on matters indirectly if it can't do directly. The important case in this aspect is K.T. Mupil Nair versus State of Kerala. In this case, the petitioner owned some forest land in the Palghat Taluk of the Palghat district, which was a part of state of Madras before it became the state of Kerala. The district was in Madras, and therefore the Madras Preservation of Private Forest Act of 1949 was applied. Under this act, the owners of the private forest couldn't sell, lease, mortgage or alienate their forest or part of their forest without the prior permission of the district collector. However, the collector, in the exercise of his powers, could allow the set of trees to be cut. This permission was brought by the petitioner for about 3,100 rupees per year. These were the facts of the case. And as such, there were many legislations involved. The Travancore Cochin Land Tax Act and the provisions of this act was rupees 2 acre per as tax, and then the powers of the collectors. Because of this, the petitioner had to pay a huge amount of money in terms of land taxes. Now, this was challenged in the Supreme Court. Now, the Chief Justice in his judgment made few observations and said that the Act did not prescribe any procedure or any procedure to compel the government to conduct the surveys or assess the lands. So, he made few very important observations stating that the proposed procedure does not necessitate the notifying the proposed assessee. This was a very important procedure to be followed by the state to ascertain whether the act made by the state was colorable in nature. There were many errors in making the procedures by the assessing authority, and then there was no procedure for obtaining the opinion of the civil court, which is common in all taxing statutes. And therefore, the Supreme Court made few observations in the matter of procedural aspects. Now, after having made an observation in such procedures, the Supreme Court held that this act was clearly confiscatory in nature, and then he gave his analysis stating that by making the petitioner to pay a forced amount and for the surveyed proportions of the forest, the act was made in the matter of a colorable legislation. He believed that since the petitioner would not be in a position to pay the tax, the government would have auctioned the land, and in case where there would be no bidders for the land for the auction, the state would actually become the auction purchaser and take the control of the land. Therefore, he held that The tax was confiscatory in nature and therefore the section 4 and 7 of the Act was declared unconstitutional for its nature of colorable legislation, which was violative of the provisions of Article 14 of the Constitution and the violative of Article 19 as well. However, regardless of the fact that an alternative way of earning the tax money could be devised, the court held that the mere fact that there was no survey conducted of the land, there were several shortcomings into the legal matters of the Act. It was very clear that the government wanted the petitioner to give up his land. Since they couldn't make him in a direct way, they made it in an indirect way through the payment of the higher taxes. So this type of legislation is called colorable legislation, and this has been invalidated by the Supreme Court in its various cases. Another important aspect of legislative interpretation is the doctrine of eclipse and waiver. As per Article 13 Clause 1 of the Indian Constitution, it says all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions, to the extent of inconsistency, be void. Now, we know that the Constitution came into force on 26th January 1950. Therefore, according to the Constitution, any article which was created before 26th January and which are violating any provisions of the Part 3 of the Constitution after its existence will be declared void. So, an important case in this is Keshav Madhav Menon versus State of Bombay. In this case, the petitioner was the secretary of the People's Publishing House, titling The Railway Mazdoor Ke Khilaf Sazish. This was a pamphlet published in the book within the meaning of Section 1 of the Press and Registration Books Act of 1867. However, the Bombay government authorities considered this to be a new sheet under Clause 26 of the Indian Press Emergency Powers Act of 1931 and said that it had been published without any authority. When the case was still ongoing, the Constitution commenced in 1950. The petitioner challenged the Act, claiming that it was unconstitutional under Article 13 Clause 1. Also, the concerns raised were whether Section 15 Clause 1 and 18 Clause 1 of the definitions in 2 Clause 6 or 2 Clause 10 of the Indian Press Emergency Powers Act was inconsistent with the freedom of press under the Article 19(1)(a), read with Clause 2. So, this was the question which came up in the court. The High Court in this case decided that the application was based on the second question. The High Court was of the opinion that the proceedings which had begun should have continued even though the Act was inconsistent and the fundamental rights were conferred under Article 19 Clause 1. The petitioner then approached the Supreme Court. Although the Act did not become void ab initio in 26th January 1950, it became void, which meant that it no longer was effectual. And therefore, he cannot be convicted after the commencement of the Constitution, as there was no existing law to convict him for violation. Perhaps a retrospective application should have been, if mentioned in Article 31, would have been a person convicted under the Act before commencement of this Constitution. Therefore, the majority decision by the court, the petitioner's petition was dismissed. Doctrine of waiver is another important aspect. To understand the doctrine of waiver, we must first understand the meaning of the word waiver. According to the Webster Dictionary, is an act of intentionally relinquishing or abandoning a known right or claim or a privilege. So the Supreme Court in its words says, waiver involves a conscious, voluntary and intentional relinquishment or abandonment of a known existing legal right where the party would have enjoyed it. Therefore, according to the doctrine of waiver, whoever is entitled to some privilege or right can waive off those rights provided that he is not coerced into doing it or does it with his free will. In a very important case of Baseshwar Nath case, the constitutional validity of the doctrine of waiver of a fundamental right was examined. Baseshwar-Nath versus the Commissioner of Income Tax, Delhi and Rajasthan and others. The facts of the case were that the central government referred the appellant's case to the Investigation Commission, and the commission directed the authorized official to examine the appellant's account. After the necessary procedures were conducted, it was held that certain amount had to be paid for a settlement under Section 8A of the Taxation Income Act of 1947. The central government was reported about the approval of the settlement, and the said approval was accepted by the state government. The appellant was asked to pay some amount of money. It was contended by the respondent that Act laid down the two separate procedures. One was for investigation, the other was for settlement, and therefore claimed that the appellant had waived his fundamental right founded in Article 14 by voluntarily entering into the settlement. Now, it was held that it was impossible to give up the basic right guaranteed by Article 14 of the Constitution, and it is incorrect to argue that by settling under Section 8A, the appellant had given up his fundamental right. So, Article 14 is based on the public policy, and therefore, it can't be waived by a mere act. The language is authoritative and places an obligation on the state that no one can be relieved of his fundamental right, and therefore, the fundamental right cannot be waived. Any fundamental right cannot be waived because the fundamental rights are based on public policy which are valued and respected throughout the world. So, the state has a duty to respect all fundamental rights, and any waiver of fundamental rights cannot be merely an act of whims or fancies. So, the state has every duty to protect the fundamental right of every citizen, and it can't claim through any act that the citizen has waived his fundamental right. And therefore, this becomes a very valid case in terms of doctrine of waiver of fundamental rights. Now, this is very important to understand all the procedures, functions, legislative interpretations of the union legislatures and the state legislatures for the effective functioning of the government in the country.